All right, let's do this all again. Welcome, everyone. Good evening. Thank you so very much for joining us for Plan Today, Protect Tomorrow, the Essentials of Estate Planning Seminar, Part 2. I am Miss Unique. I'm the membership coordinator for the Scholarship Plug, and I am your host for today. Thank you so very much for joining us. The Scholarship Plug, on behalf of Ms. Shelly Cassius-Parnther, who is the founder of the Scholarship Plug, our mission is to break cycles and empower futures to help students get paid to go to college. So today, our host, Judge Tamar Hamilton, is an estate planning and real estate attorney dedicating to helping individuals and families protect their legacies. With extensive experience, she focuses on making estate planning accessible, particularly for undeserved communities. Beyond legal representation, she is committed to education and empowerment, equipping clients with the tools to secure their assets. Ms. Tamar aims to inspire and inform, bridging the gap between legal knowledge and actionable steps to build generational wealth and security. So again, today she will be here to teach us all we need to know about probate. But before she starts, she's going to also introduce or welcome or going to share a few upcoming workshops that she will be participating. So more information that you can also be a part of. So Ms. Tamar, I welcome you to the floor.
Thank you. Thank you so much, Miss Unique. And as part of our recording, I just want to correct, I believe, I'm not sure if she's a prophet or something, but she introduced me as Judge Tamar Hamilton,
I'm speaking it
which
into
which is
existence.
my future aspired career. I am attorney Tamar
Oh
Hamilton,
my gosh.
and I am so happy to be here. Looking forward to just sharing all this knowledge. I am sure that you are going to leave this platform this evening empowered, more knowledgeable, and definitely being in the position to make better decisions regarding the protection for yourself and your family. And our goal is to save money, just like people look for scholarships to save money. So I want to thank the Scholarship Plug as well for their continued effort and support to bring education and awareness, not just to those who are looking for scholarships. And as you know, everyone of all ages go to school, but also our families, just how they can save money for themselves and their loved ones. So thank you, Unique and
Of course.
Shedley and the Scholarship Plug family for hosting this seminar. There are a few seminars, as you can see on the screen. There is a new home buyer workshop that is happening this Saturday. And if you're available, check that out. It's posted on my social media, Facebook, Instagram, and also the website. If you or someone you know can benefit from the knowledge, the speakers, the information that's going to be shared, you're welcome to join us.
Awesome.
All right. So before we get started, please, I want to interact with you tonight.
Okay. All right, sorry guys. Let's just see. I think we might have lost our host. Just give us a few more minutes. Sorry. Again, if you're just joining us, thank you so very much. You have not missed anything. We are just getting into the meat of tonight's workshop. So just wanted to, let's go back a slide until our host joins us again. Just want to share with you just a little bit about the Scholarship Plug. If you're new here, you've never heard about the Scholarship Plug, just wanted to share with you about our services and how we help the community. So we believe that no student should miss out on college due to financial barriers. And so by providing scholarship training, financial aid support, and personalized advising, we equip students and families, sorry, Okay, sorry. Yeah, so we equip students and families with the knowledge and resources they need to make higher education accessible. So with your support, we can continue expanding our Get Paid to Go to College initiative, reaching more students in our community and breaking cycles of financial hardship through education. So every donation helps us provide sorry. Every donation helps us provide critical workshops, one-on-one mentoring, and scholarship resources to students who need them most. So again, thank you so much for joining us. We are sharing today all you need to know about understanding probate. And our host for today, I am Miss Unique, the membership coordinator of the Scholarship Plug, and we will be hearing from none other than Miss Tamar Hamilton, who will be joining us shortly.
Again, Tamar was kicked out. She'll be right there.
Oh my gosh. Okay, thank you. Okay, we are back on track. Let's get the ball rolling. Miss Hamilton? Okay, I think she's joining us.
All right, I
All
am
right.
back. Sorry about that. Not sure what happened, but we are definitely going to continue.
Let us continue. I think somebody wanted you to wait on them. They were trying to join, so.
I guess we're back. I want to interact, as I was saying. Please, while I'm sharing, if you have any questions, generally speaking, or any related to any specific circumstances you may be dealing with, we can chat. So type your questions or statements or comments in the chat area, and Yannick from the Scholarship Plug will make sure we address those questions or concerns or share tonight. So let's get right into it. Probate. What are we talking about? A lot of people, when they think of probate, they know, okay, yes, it is true. For you to end up in a probate court or being part of a probate proceeding, and there's no other word for probate. It means someone has passed away. It means there's a deceased person and there are some assets, whether it's home, their bank accounts, there's something that the loved ones of this person needs to access, but they cannot do so without seeking the court's assistance. And why is that? Plain and simple terms, keep this in mind. A dead person cannot sign. A dead person cannot transfer property. A dead person cannot add your names or add you as a beneficiary to any of their bank accounts or investment. Dead mean life is gone, and whatever is left behind, if there is no writing. From part one, we spoke about the different type of instruments that we use to protect ourselves, our families, and our legacies. And part of that proceeding is a probate process. And the reason why we're talking about it tonight is our goal is to avoid it. But before we can avoid something, we need to understand it. So what is probate? I've given you some clear definitions. There's no AKA word for it. Someone has passed away, and because there was no writing, or there's not much instructions that was given, or even there's a writing, there are just areas of that person's life that you have to access in order to get a hold of those assets. And that's the legal process of settling an estate after death. So you're in probate, you know death has happened. settling an estate. People think of an estate as a big word. No. An estate could simply be your bank account with your penny or your millions of dollars. That's part of your estate. Your estate could include that beautiful, expensive art piece that you purchased at an art show, or you traveled abroad and you just brought something back that is sentimental to you. It could be your favorite watch. It could be your home here or anywhere else in the world. It could be land. It could be china. It could be silverware. Anything that you owned or that you had control of during your life is part of your estate. And I'm saying this because even as we are planning our estate, I always get the question, well, what do I own? Everything that you are in control of, both in your personality, your clothing, your shoes, your bags, everything is of value. Now, I'm sure nothing you have that you are accessing every day wasn't free. Even the very plates in your kitchen, your chinas, they did not come to you free. There, and even if they did, someone paid value for them. So it is time when we say, analyze your estate. Just look around you. Look at the computers. Look at your phone. Some of us, our phones alone exceeds $500, right? There's always something in your possession of value. And those are the things that you would want to settle as part of your estate. And so, as part of your estate planning and understanding probate, it is important that we begin, even if it's a notepad with pen, begin to write down the things that are part of our estate, the businesses we own, the cars we drive. Whether or not you have a loan on it, it is yours. Your name's on it. You are responsible for it. So now you want to begin to look in your estate. What do I own? What am I in control of? And what do I stand to inherit? The other thing about understanding probate is the timeline. There is no quick fix. There is no expedited probate. I currently have several matters where opportunity was present for the family members to either benefit from a program that would allow them to renovate the home, or sometimes the cities have programs where they can get air conditioned. They just grants for different things that they could benefit from, only to find out, oops, you cannot benefit because the property is in the name of someone who has passed away. So therefore, you cannot take advantage of that program because we don't know who the rightful heirs or the beneficiaries of this estate now is. So we could not just have some quote unquote person come by to sign documents to take out any kind of loans or grants or anything on this property. So here you are trying to take advantage of this opportunity, only to find out it has missed you because guess what? We're in probate. And depending on the circumstances, it could be 4 months, 6 months. And I've seen situations where there's now contesting and people are not in agreement with who is going to serve or the information being given. And now one of the beneficiaries, they want accounting for something because you have lived out the property and you should be paying, and all sort of conflicts that could come in. And so these are the things that affects the timeline. Not only do they affect the timeline of the probate process, but you can imagine cost. Attorney's fees are going up. Court fees, every time we've got to file new documents, we've got to publish, we've got to ask some more documents because someone is not in agreement. We've got to serve more people because we've got to find out who the real beneficiaries are. Every time you're part of a probate process, one of the biggest concerns for those that have to go through this process is the cost and the timeline. Because you may want to be able to get this property to refi. There may be a mortgage and now it's in foreclosure. And these are all circumstances that goes hand in hand with probate. The longer we take to understand the probate or start the process, if you are there, then you have no other way out but to go through probate. If you are a loved one, just happen to have left things without the proper process or ways, and we're going to talk tonight about ways in which strategies that we can implement to avoid probate. But if you're there, you're there. Do not linger. If you have property, bank accounts, or any assets that are still lingering in the name of a deceased loved one, it's better to start sooner than later. Cost changes every day. There are so many other third parties, publication companies that are involved, letters that have to go to different administrative expenses, and those change. So the cost is not fixed, and it is certainly expensive. Probate proceedings are not private. So you can imagine, as I just mentioned, publication. When you have to go through a probate, especially when there's no writing and we have to determine who the heirs are, we can't just take your word for it. We have to publish certain documents in the public to ensure that if someone out there feels that they may have a claim against this person's estate, and now I'm using the word estate because now you know what an estate consists of, small or big, right? Here or there, part of your estate. Now, when we hit the public records, now we're opening the entire estate for everyone to come in and see, hey, does this person owe you anything? Do you have any claim against the estate of this person? Here is your chance. Here's another situation that could further extend the timeline and also increase the cost. So it's good to understand probate. It's not a quick fix. There's no alternative to it because a dead person can sign. And if you're there, you're there. And we will take you through the process. It's not a simple process. And in most cases, you will almost always need an attorney to guide you through that probate process. All right, so let's move on now. Why do we want to avoid probate? If we can, we really, really should. Again, time is money. Without probate, you can be in possession of the assets that was part of that estate in a much shorter time. Whatever instrument was used to convey it, in some cases, you can actually be in possession immediately of that bank account, of that home, accessing all the assets that the person has. There are things that you can do now to limit and completely avoid probate. These are the ways: avoiding probate, time savings from what we see, definitely cost savings. I don't have to go over that again. Court fees, attorney's expenses, administrative fees for publications. The other thing is privacy, right? We want to keep our estate matters confidential. It always, almost always, I get someone who's offended. Oh, they had to publish this person, my mama, my parents was a good person, and now all this thing is coming and everybody's fighting and everybody knows now what's going on because we're constantly have to publish and be searching for people. So without probate, it's private. You have the opportunity while we're alive, while our loved ones are still with us, we have the opportunity to prevent all of this longevity and costs and complications and exposure that we will be giving our estate for different things to happen, whether they be just or unjust. But we have the opportunity now to take some actions that can help us to avoid probate. And again, control. I always say this, ink is cheap, litigation is expensive. Any kind of lawsuit that you will find yourself in will cost you. But we have the opportunity to right things. We have the opportunity to make our wishes known. We have the opportunity to protect everything that we own, that we're in control of, our assets, with a write-in. But again, as we said in part one, it is very, very important that we use write-ins that are valid and legally sufficient to carry out your wishes and to protect your assets. So don't just go download some document where you don't even know which state laws was used to prepare that document. And I've seen that. I've seen families that bring their documents in for review, and reviewing them, and I'm reading through, it's like, oh, these are based on the state laws of such and such a state, totally unrelated to the state where your assets are. So please be very careful about that. This is a very personalized, customized process. It is your wishes, it is your words that's going to make the difference, and your words are powerful. They are respected. So let us utilize some of these strategies to now put things in writing or take some actions. Leaving this seminar tonight, I expect each of us to take some actions that will get us closer to the point where we have peace of mind, we can avoid probate, and our assets in our estate, yes, we ourselves are estates, right? The clothes on our back, we bought that. That's an asset in our estate. Anything we own that we have control over, it's part of our estate, and it is worth protecting, regardless of how anyone thinks the value. Your value, my value, listen, it's very personalized. Let us now begin to really value the things that we have and that we're in control of, and do all we can to save time, money, keep it private, and keep it under our control. Go to the next. All right, so let's do one. We're gonna do one strategy at a time. This is the main part of tonight's webinar. Please pay very close attention. This is information that clients pay hundreds of dollars to get the help of attorneys to determine which one is best for you. It is very personalized. Each of these strategies, you definitely fit into one of these. So let's start talking about strategies that you can implement today to ensure that you, your loved ones, and the assets in your estate are protected. Strategy 1, having a living trust. When you have your assets in a revocable trust, they will never see probate. In part 1, if you haven't seen it, I believe there's a link. You can always watch it. We talked about the will versus the trust. A will always will go through probate. It is better to have a will than not, because at least with a will, you have a writing that is your words, your instructions, your testament to what you want to happen to your estate. With a living trust, everything that is in that trust will be automatically dispersed from the trust. Your living trust becomes irrevocable when you die. So that way, everything that you've stated is protected. When it becomes irrevocable, it means whoever you've left in charge as your successor, to see to the distribution of those assets. They have no power. They cannot change, they cannot amend, they cannot revoke anything that you stated. The beautiful thing about a living trust, you retain the power to make all the changes that you need to make, to add assets, remove assets, change beneficiaries, change who your successors are, add co-successor trustees. You retain that power. Now, let's talk a little bit about living trusts. Of course, with our time, we're not going to be able to really, it's a very deep subject, but we'll get into it. A living trust is almost like you're building a warehouse. In this warehouse called your trust, which you would name, right? In this warehouse, you can put everything you can think of. You can put your car, your bank accounts, your homes, your land, anything of value that you are purchasing, and you want to make sure these things are not part of any probate proceedings. This is the purpose of a trust. It gives you the protection. It gives you their certain shield against certain legal process. And a lot of times we talk about protection against creditors. There are certain protection that is given in when your assets are in trust. Again, every circumstances can be different. And that's why it's important before you decide which of these strategies to implement, set up your consultation, speak to the attorney about your situation, and we will help to guide you along the way and to help you decide which strategies best suits your situation. The living trust, I also want to tell you, is also important if you have minor children. 100%. You want to make sure any assets that they stand to benefit from is left in a trust. Why is it also important? In the trust, you can put assets where their spouses, it does not become part of any marital dispute, where their spouse cannot make claim to any assets that are left or that they obtain by means of this trust. So the trust is a major instrument. I always liken it onto a warehouse. You can build a trust. Anyone can have a trust. But if it's an empty trust, there's nothing in the trust, then what is the purpose of the trust? If you have nothing to put in that trust, then there's absolutely no need for you to have a trust prepared on your behalf. And like I said, once you have a trust, it's like a warehouse you've built. It carries with you forever, and you have to make sure you are utilizing or funding that trust. So every time you buy a new property or you obtain a new asset, you've got to think, how do I put this asset in the name of my trust to ensure that it's part of the warehouse, it's protected, and in the event of death, it does not have to go through probate. The next strategy that we can implement in order to avoid probate is joint ownership. Now, joint ownership can occur whether it's property or business, even just buying a car. This is information that when you possess this kind of knowledge, you now have to look at the different areas of your life based on your circumstances to say, where can I apply this strategy? Do I own a home? Do I own land? Am I in a business? Do I own a business where I am the sole person listed? And if so, who would I want to benefit from my interest in this asset? And remember now, as we use the word assets, it could be the shirt on your back. It's your asset. It's what's valuable to you. Joint ownership is important, but not only is it important to have joint ownership, the right legal language, the right terminology needs to be part of these instruments to ensure that it's avoiding probate. So, for example, if you and your partner purchase a home together and your name is listed just as Tamar Hamilton, and say, let's see, and I don't want to mess up Brad's name, Brad Parther. Brad, you got to help me with that last name. Arthur, thank you. So let's say Tamar and Brad decides to buy property together, and we're just listed Tamar Hamilton and Brad. There's no legal language. What happens if something happens to Tamar or something happens to Brad? Brad would have to turn around and open an estate for Tamar just to secure the interest that Tamar had in that partnership, whether it was property, business, or any kind of asset. Now, how could we have avoided that? We need to ensure that there are survivorship language included in these instruments. Now, guess what? Maybe we didn't want survivorship rights. Maybe Tamar didn't want Brad to have her share. Brad didn't want Tamar to have his share in the partnership or the property or whatever the case may be. So what do? How do we avoid probate in that case? We, in that same document, can use other instruments to ensure that our interest is present, but we can assign a future interest to the person or persons or entity or animal, whatever the case may be, or organization that we want to benefit from the share that we have. So joint ownership is important. And even if there is no joint ownership, let's say I own property and I didn't want it to be a joint ownership, but I want to avoid probate. What am I going to do? I'm going to, again, maintain a present interest, just like we do in a living trust, with the right to do what I want to do with my asset, but I'm going to ensure that I have legal language in there that protects the future interest of that person, that loved one that I want to benefit from my interest in that asset. So I want you to start thinking as you analyze your assets, joint ownership. And if not joint, what can I do to keep this present interest, but secure the future interest in such and such person or organization? Let's look at the next strategy. Bank accounts and investments. Please, 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 at the very least, please make sure, effective immediately, whenever you walk into your bank or speak with your financial investors or your banking clerk or officer, you should ask, by the way, do you see a beneficiary listed on this account? And more specifically now, because I recently had a case where the client stated there are beneficiaries listed. And for some reason, the bank did not consider them paid on death or transferred on death designations. And now they're making this family open an estate in order to get a court order. So it is important that you are now using the right language. Do I have a paid on death beneficiary listed on my account? Meaning, if I'm not here today and this person presents their ID and my death certificate, which is going to be public, would they need to do anything else to get the funds that are in this account? It shouldn't be. When you have a payable on death or a transfer on death designation on your accounts and your investment, no need for probate, no need for order. They just need to be able to identify that this is the person by that person presenting their valid ID, and the transfer should be complete. So at the very least, you don't have to have someone joint with you on your account. And even if you do, you still want to think, should something happen to me or us, if that person is not your only or sole paid on death beneficiary, then take the step and add that person as a beneficiary. Add those persons, add those organizations. You can add as many beneficiaries as is allowed, and on that beneficiary you can state the allocation. You, whether if at the time of my death it's $10, please, instead of taking my hard-earned money and send it to the state as unclaimed funds, please give $1 to this person, give $2 here, give 3% here, 5% to this person, 1% to this organization, 15% to this one. You can make your designation. This is the power that we have to take control of our assets, everything that we own, and put our statement on them. Make it plain. And when they says, oh, yes, we see you have this person here, say, oh, great, may I have a printout of that? That's the next error I'm seeing. Clients who have statements showing there's a POD, by the time, whether it's because of a merger, whether it's because systems change, again, these are computer, things do happen. But we're finding more and more where for some reason, information was either not uploaded or not transferred. There was a merger. Make sure anything they're confirming, oh, say, great, may I please have a copy of that for my record? And now you're going to put it in that folder or that safe cabinet that you have with your estate planning documents, your deed, your trust, your wills, your powers of attorney, your healthcare directives. You're now going to have a place where you are keeping these important documents so that it's easy for your loved ones to locate them when it becomes necessary, whether it's during your lifetime, whether it's during an emergency. You want to make sure these are in a place that those that you've trusted to know that you have these instruments, they'll also know where they are securely kept. So again, when you speak to your investment advisor or your banker, to inquire, do I have paid on death or transfer on death? Some use POD, some use TOD. You let them know, listen, basically, I want to make sure that this money in my account is going to go to this person or persons or organizations and not stay. I think I was muted. Yes, so we want to make sure these funds are not taken out or left at the bank until it's drained with fees or it becomes unclaimed funds. All right, let's move to the next strategy. Time is going and I want to answer some questions. Beneficiary designations. A lot. Life insurance, retirement accounts, and annuities. Please update these. If it has been 2 or more years since you've checked on any of your policies or retirement accounts or those special, bank accounts, annuities, any type of money marketing account, please double check if it's 2 years to make sure whoever you have listed there as the beneficiary and whatever the percentages of their allocation, it is still what you want. Again, here's an example. I recently had a couple met with me to do their estate planning. And when I started reviewing their retirement accounts and asking them who are the beneficiaries, it was then that the husband realized the ex-wife was still and we're talking this was like 10 years ago, was still the beneficiary on one or more of his retirement accounts. And so right there and then he was able to call the company, but it's a process. You never know what could happen within that time frame because it's going to take time. They said, we will send you the necessary forms. You will have to fill them out, get them notarized, and return them to us. That's time passed. So once a year, at least if 2 years have passed, please check on your insurance, check on your beneficiary designation, make sure they are still what you want them to be. Next strategy. Gifting. There's a lot we can do if we have our children, our loved ones, and we know specific assets. And this we also call specific designation, right, of gifts. If you have a special, sentimental, or a home, and you know exactly who you want to benefit from this asset, go ahead and gift it while you're alive. There are different ways you can reduce the size of your estate by giving assets while you're alive. If you know you want a certain organization to get a certain item, you can already allocate that as a gift to go specifically. And that also reduce certain estate taxes. So depending on the value of the gift, you can start and you can still be in control. If this is done via a trust, especially, you can still be in control of the asset, but the trust is already poised and ready to gift the items that you have specified that must go to specific individuals or organizations. So I hope you are taking some notes and I hope you have some questions because these strategies are extremely important and they're very practical things that we can do just slowly every day. Every day we're coming in contact with our assets. We're coming in contact with our estates. Again, we are that estate. Everything we can have control over, everything we own, it's our valuables. And now we should look to these strategies to see what could I implement to make sure I am protecting the assets that I'm in control of. Go ahead to the next. All right. So again, we want to avoid some of the common pitfalls and mistakes that we will find. And I gave you some during the examples. No point in creating a trust and then leaving your assets, what I call naked. I created a trust, but oh, I forgot to transfer my property. That should not happen. And that's why it's important that you work with a knowledgeable attorney that understands that, yes, it's great. I'm creating a trust for my client, but I also want to make sure my client has assets that are ready to fund this trust, even if it's a bank account, right? Clients that have business, your business interest should be assigned to your trust. So everything can be tied back to your trust. Make sure you are working with an attorney that is knowledgeable, that can guide you in this process, funding your trust and utilizing your trust. Outdated beneficiary designations, we spoke about that, and I've given you examples where I've seen beneficiaries who have passed away a long time and they were still listed there. Very dangerous. You want to make sure you are regularly checking with your bank, checking with your investment to make sure your designated beneficiaries are who you want them to be, and they are also getting the percentage of what's there as you would want it to be. And finally, incomplete or incorrect estate planning, what happens? It leads to probate. Because if you believe that bank account had a paid on death beneficiary, or that bank account had your trust listed as a beneficiary, or, oh my goodness, I bought an investment property, or I bought land and I totally forgot to put it in the name of the trust, and something happens, we just defeated the purpose. And even if you made this mistake of purchasing an asset outside of utilizing one of the strategies to avoid probate, as long as you're here, it's never too late. There's absolutely nothing that we cannot correct under the law. If mistakes were made, we can find how do we correct this? How do we ensure now that I bought this, but I didn't put it in the trust? Let's get it in the trust for you. Let's fix your joint ownership. Let's make sure your present interest is there with all the rights you need, but also the future interest in that asset is also protected. If you're in business, please make sure you have a writing, whether that business is an online business or a physical location business. Please ensure that you have the proper business documents drafted to protect your interest and the interest of your loved ones. A lot of people are creating businesses online, digital businesses. For it to be valid, you still need to ensure that you have a registered business in the state in which you are doing business to make sure you are positioned to take advantage of all the opportunities that are likely to come your way, and to ensure your interest in that business passes the way you would want it to pass to your loved ones or organization of your choice. So, as we have a few minutes that I want to leave for us to take some questions. Again, you have the opportunity, please consult with me, consult with an estate planning attorney if you're not in Florida or you have loved ones. And this is knowledge. Let's share it, right? We don't want to keep this to ourselves. If you know someone that is at risk of facing probate, is at risk of maybe owning assets that are not protected, share this information with them, whether they're here or abroad in another state or another country. This information could save them thousands of dollars, could save life, could bring peace of mind, could bring happiness to homes and families. So please do not hesitate to share this information, direct them to the websites. We have free consultation. If they're in another state, I encourage everyone, please consult with an estate planning attorney, review and update your beneficiary designations everywhere: CDs, investments, savings, checking, life insurances, bank accounts, pension plans, whatever it is that you may have. It is your valuable asset and it's part of your estate. Consider a trust for major assets. Major assets meaning valuable assets to you, especially real estate. Consider a trust. That's the biggest instrument that you could ever create to avoid probate. And finally, and once again, educate family members about your estate planning, what you're doing, where you're securing and keeping documents. And guess what? This is the road to a peaceful, happy life where we can save more money. We can make sure what we've worked hard for, what we've saved, what we've accomplished, what we've accumulated here, there, and abroad are properly distributed upon our death. And we can continue to own and enjoy these things while we're here for our benefits. But it gives us peace of mind to know that when we are no longer here, there's no need to fight because we have put ink to paper and our wishes have been properly stated. So I want to thank you so much for joining us this evening. I hope you have some questions. If we don't get to answer all the questions this evening, you have the opportunity to reach out to me. That information will be given to you here shortly. So go ahead, Yanni. Do we have any questions?
Awesome. Yes, thank you so very much. Yes, we do have questions here. So the first question, if I want to sell everything that is in my estate and all monies earned goes to my minor child, would that go in my living trust?
Yes. And that's the best place to put it. And the beautiful thing about the trust, it's customized to you. It sounds like you. It is written with your words, your wishes, in plain language where there's no ambiguity. You understand it, and anyone coming after you. And one of the good things, especially with minors, when you're no longer here, because you're the one with the power to make changes.
Right.
But when you're no longer here, that trust becomes locked. No one can revoke, amend. They can only carry out the task of making sure everything you have, the trust, they now look to the trust to know who owns it.
Awesome. Well said. Thank you so very much. I'm gonna open up for just one more question. If no one has any questions, you can consult. You can book a free consultation rather with Miss Tamar. Here's the link or the phone number. You can take a screenshot of this information. You can book a free consultation with Ms. Tamar if you have more questions that we're not able to address, or you may be shy. You may not want to share it online for everyone to hear, but of course you can reach out to Ms. Hamilton and she'll be happy to assist you with any questions you have. Again, thank you so very much, Ms. Hamilton, for such an insightful information that you shared with us today.
My pleasure.
Awesome. Thank you. Again, just real quickly, just wanted to share also the scholarship plug. We're a nonprofit organization and we're all about helping students and changing the lives and transforming lives through the power of financial aid and the possibilities that are available through resources such as others giving back to the community. And so as a nonprofit organization, we're all about helping students get paid to go to college. So we want you to join us in making a difference. And you can visit our website to make a donation. You can visit our website at thescholarshipplug.com. You can visit our donation page and help us spread the scholarship education and post-secondary opportunities that are available, because together we can create brighter futures. So again, the link, thescholarshipplug.com/donate. Thank you for believing in the power of education. And thank you again, Ms. Tamar Hamilton, for sharing this information with us. Again, if you have questions for the scholarship plug, if you want to know more about what we do, here's our information, our email, phone number, and the link, and also a QR to contact us as well. Thank you again. If you want to get in contact with Ms. Tamar Hamilton, if you missed today's session, you can reach out to Ms. Hamilton for a free consultation. Thank you so very much for joining us. And we are looking forward to future workshops. Earlier, she had shared with us. Thank you, Ms. Shelley, also for sharing the link in the chat. So if you want to quick access to the link, you can go ahead in the chat. The link is available there as well. But thank you again. And of course, we look forward to future workshops as well with you, Ms. Hamilton. And if you are available, we shared earlier 2 other events that she will be where she'll be presenting as well. And you are welcome to join that session as well. The link also to contact or to book a free consultation is also available in the chat. Thank you guys so much for joining us. We hope you have a wonderful evening. Stay safe and be blessed. Thank you.
Thank you. Good night.
Good night, everyone.
Good night. Thank you.
You're welcome. Have a good one.
Great job.